Hi friends, this is me Cleta Lorenko, and today's topic what I am going to deal the powers of the court are addressed in chapter 3 of the Code of Criminal Procedure. Now this is the topic which I have previously uploaded a video in the YouTube. Now in this topic we are going to talk about a continuation in a criminal trial proceedings. So here what it says, as per section 26, subject to other provision of CRPC, as per the Amendment Act of 5 of 2009, any offences under section 376A, 376AB, 376B, 376C, 376D, 376DA, 376DB or section 376E of the IPC shall be tried as far as practicable by a court presided over by a woman. So now these are the sections under IPC which has been inflicted over a woman, where a woman has been affected. So here under section 26, where it says that it also provides for the trial of offences under any law. So now what it says, it provides that if any law that by which court offence shall be tried. So here the court have to try this type of offences, and if it is not provided by such law, the offence may be tried by the High Court or by any other court shown in the first schedule of CRPC to be trialable. So where the reference should be to the first schedule of CRPC. Now reading of this section make it clear that any offences under IPC or other law may be tried by the High Court. Now, the role of the advocate. Now, the advocate must develop a habit of referring to Schedule 1 of CRPC to find out the irregularity, if any, in a trial of offences. Now, the advocate, whenever the case comes towards them, they have to have the habit of referring to Schedule 1 of CRPC and find out what section should be implemented for the offences that the person has been committing. Now, when we talk about the punishment given, a High Court and a session judge or additional session judge may impose any penalty authorized by law, but any death sentence imposed by session judge or additional session judge must be confirmed by the High Court. Now, such detention should not go beyond the magistrate authority as outlined in section 29. Now, if the magistrate imposes a section of 3 months and a fine of 1,000 rupees, the imprisonment in the failure of a fine payment will not exceed 1/4 of maximum punishment imposed by a magistrate under section 29 of CRPC. So now whenever it comes to the punishment, where High Court and the session judge or additional session judge may impose any penalty authorized by law. But now, like for example, a death sentence. Now, if it's a death sentence where a district session court can also put a death sentence, but they also have to take the permission from the High Court, which I have explained it before the slides. Now, amount of the penalty. Now, when we talk about the amount of the penalty, where the court may impose a fine without a specific sum, but under section 63 of IPC the fine is unlimited. So like when we talk about fine, where there is no sum is expressed to which fine may be extended. Now the amount of fine to which the offender is liable is an unlimited, but it shall not be excessive. Okay. Now, sentence of imprisonment for non-payment of fine. As per section 64 of IPC, when the offence is punishable with imprisonment as well as fine, and the offender is sentenced to a fine with or without imprisonment, and every case of an offence punishable with imprisonment or fine, or with fine only, in which the offender is sentenced to a fine, in such a case, the court can direct a default of payment of fine. Now, the accused shall suffer imprisonment for a certain term, and in such imprisonment shall access to any imprisonment to which he may have been sentenced or to which he may be liable under commutation of a sentence. So when we talk about commutation of a sentence, it is lowering of a sentence of a person. Okay. But when a person is said to given a fine, it to not be excessive. Okay, it should be what is mentioned in the section. So in the chapter where we come to know that a provision related to trial of offence or constitution of criminal court or territorial division or power of the court and sentence to which may be passed by the court, we also have to discuss the role of an advocate in respect to above points. An advocate being an officer of the court owns duty not only towards his client but towards the court. And here what happens is, unless above provisions are within his knowledge, he cannot play his role effectively. So whatever the role he cannot play it effectively. According to provision of law, he have to go. And each and every provision has a specific purpose, and an advocate can play a role keeping in mind the purpose behind the provision. So now this is the end of the chapter. Thank you for watching, and guys, please do like and subscribe to my video. Thank you.